former President Jacob Zuma's legal team has sent a letter to the state capture inquiry indicating that they intend to launch an application for the recusal of Deputy Chief Justice Raymond Zondo. Zuma has been arguing that the commission was infringing on his rights by trying to provide him with an opportunity to refute the testimony of witnesses implicating him in wrongdoing. Now, of course, there is a clear distinction between the court of law and a commission of inquiry. To help us unpack some of these differences, then tonight we're joined in studio by Advocate Modidima Mannya, who is the Executive Director of Legal Services at UNISA. Good evening, and thank you so much for your time tonight. It's interesting because when you take a look at this petition that is currently being made by Jacob Zuma, you're very clear on the fact that legally, it doesn't even have much of a basis because courts of law and commissions of inquiry don't necessarily operate in the same way.
Yes, because, and good evening to your listeners and to everybody here. I think the first question that we must ask, regardless of whether the Deputy Chief Justice must recuse himself or not, is whether anybody in their right mind really think that Justice Zondo can scoop to the low level of being personal in a matter of this nature. I think that on its own is a bit of a reflection on those who are asking for this. The second issue is that, yes, there's a clear distinction between what a judge, sitting as a judge, would be confronted with in a recusal application and what any other person sitting in any other tribunal would do. Of course, the test is whether, in both instances, whether there's bias or not. But I think the fundamental issue is that this commission is not there to make a judgment against anybody. This is an investigative body which is obtaining information, which will be processed, and Judge Zondo will ultimately make a report to the executive and tell them what he thinks. It will be up to the executive to decide what should happen. If, for instance, Judge Zondo were to recommend that I be charged, it does not mean I'm going to appear in court the following day. The National Director of Public Prosecutions still has to take a decision. In fact, it firstly starts with the executive on how they want to deal with the matter. And they are not bound in law by the recommendation and the advice of the commission.
Of course, the legal test for a judicial officer to recuse himself from any case that he or she may be presiding over is quite a tough one. It's not an easy thing. So you don't just wake up and decide that a particular judge is biased and therefore they must recuse themselves.
Yeah, definitely. In fact, the Supreme Court of Appeal has set the threshold very, very high. I mean, yeah, and correctly, you don't wake up and say, this one doesn't like me. But by the way, it is the person to whom you make the application who must first take the decision whether there are sufficient grounds for a recusal. And if that person believes that there's no basis, then he's not going to recuse himself or herself.
The other thing which you point out is the fact that a judicial commission of inquiry can be chaired by ordinary citizens, quite frankly, and that it's not necessarily a judicial officer or presiding officer that needs to be the one overseeing the processes.
Yes, definitely. I mean, anybody. We have had commissions, if you know, the commissions on traditional leadership disputes were not chaired by lawyers or judges, as a matter of fact. And there are a number of other such commissions which would have taken place without being chaired by a lawyer or a judge. But I think the world over, globally, the view is that a judge presiding over a commission of this nature lends it more credibility and a lesser risk of any form of bias or irregularity. And as I say, this is a Deputy Chief Justice. I don't know why he would scoop that low to discredit himself. I mean, he holds high office, he holds high responsibility. We look upon him to deliver the information that the public wants. It's not about him, it's about the public.
In the same breath, however, one can pull up the findings of the Seriti Commission into the arms deal, and we take a look at how that has fared and the fact that it was taken under review. And of course, Judge Seriti was a sitting judge at the time too.
Yes, but the correct procedure is to take it on judicial review now before a court of law. And the judge who presided at the commission is not going to be part of that bench that hears your review application, in any case.
So the best thing then, you think, for the former president is for him to sit it out, wait till the process reaches its conclusion, and then take whatever findings or whatever report on review?
Yes, look, generally the court's attitude is that they don't want to interfere in incomplete processes. So this process is incomplete. By the way, former president has already appeared before the commission. He has given evidence. For me, it's not, I don't know what is the issue. He can go there. If he can't remember, he can tell the commission that he doesn't remember. I don't know what this drama is all about.
Ultimately, Judge Zondo is going to have to make a call in terms of how he responds to this request. What are the options that are available to him?
Well, look, the understanding is that they're threatening to go to court. And I don't know what they're going to tell the court, but I suppose let them go to court, and I'm sure the commission will meet them in court.
It's the first time that we're seeing an actual chair of a process like this, an inquiry tribunal, being asked to recuse themselves. So in terms of precedents and law, what would be used in this instance?
Well, look, Kathy, it happens all the time. I mean, in disciplinary hearings, in many other tribunals, people do request, and that's not whether people can ask or not, but it's whether there are any facts on which you can legally ground your request for a recusal. And of course, it also depends what kind of tribunal are we talking about here. But I think the principle is that you can't simply allege that you are not liked, or because you feel threatened, you feel that a person in the position of a deputy chief justice must recuse themselves. I think.
Are we likely to see the work of the commission being delayed at all by this request?
Not at all. I think what those who think that the judge must recuse himself are making a mistake. The commission will complete its work with or without them. The purpose of them going there is to afford them their procedural rights. Allegations have been made against them. Whether they go, they don't go. If they choose not to go, they've effectively waived their rights. So whatever conclusions the commission make will stand. You can't be afforded an opportunity to come and refute such serious allegations, and you tell the commission that you're old, or you don't like the commission, or it doesn't like you. As a result, you cannot appear before it.
What happens when more and more witnesses decide to effectively do the same thing?
Look, the commission has got the power to subpoena witnesses. But of course, the commission doesn't have the power to open their mouths. So they can be subpoenaed, they can go there, and you have seen some people who didn't remember anything, and they can go there and remember. But I think the mistake that they are making is to assume that, playing some tricks will influence the evidence that is placed before the commission. Remember that it is not a situation where, Kathy, they wake up in the morning and say, come here. There's a lot of back office work which has been done. There are investigations. You have been furnished with witness statements. You are being afforded an opportunity to consult with your legal team. So there's a whole process. And I think if you look at the rules and the procedure of the commission, is that you don't necessarily come there for the whole day. If you accept certain allegations, they are regarded as accepted. If you dispute certain allegations, they are regarded as disputed, and that's what the evidence is limited to.